This is attorney Mark Rogers of the law firm of Angermeier and Rogers, and today I'm going to give you some information on what the common estate planning documents are and what they do. So we're going to see that we break this down between single and married people, and also using a trust as the center of your plan or having a will. So we'll start with the estate plan that you would set up for a single individual on the simple side, and that would involve 3 documents. One is a will, the second would be a power of attorney for finances, and the third would be a healthcare power of attorney. So a will is a document where you can express your wishes about where you want to see your assets go when you pass away. An important thing to know is that the will is going to govern assets that you own in your own individual name, rather than assets owned jointly with somebody else or in a revocable trust, and also assets that don't have a beneficiary designation attached to them. So document number 1 is a will. The second document is going to be a financial power of attorney. There you will name an agent who can act on your behalf when you're unable to do so, and that person will have control over most of your financial and legal decisions. The third document that you want to have is a healthcare power of attorney. Here again, we're going to name an agent. This person is called a healthcare agent. And what you want to see happen there is that that person has guidelines for what to do if you are not able to make your own healthcare decisions. Usually the situation is that you're hospitalized and unable to communicate effectively with your doctors. Then you're going to probably want to leave guidelines about how to handle issues like a permanent loss of conscious awareness, and then severe dementia, and also terminal conditions. So those are the main documents that you'd use as a single individual. If you are married, you're obviously going to have a will for the husband and a will for the wife. Same thing for the powers of attorney for healthcare and finances. So there's no great difference between a single person and a married person, except that each member of the couple will have a document. The next thing we want to look at is, what about a single individual who uses a revocable living trust? So the trust is going to take the place of a will as the place where you leave information about where your assets should go. But just like a will, those documents depend on how you hold title to your assets. So for a revocable living trust to work, it needs to be the owner of your assets. So for example, if I have a house titled in the name Mark Rogers, I will do a new deed so that the asset is owned by the Mark Rogers Living Trust. And that's called the act of funding a trust. And that's important because that trust will help you avoid probate, whereas a will does not. So even though you have a revocable living trust as a single individual, you will also need to have a type of will. It's a backup or a safety net called a pour-over will. And that document will simply say, if I missed something, it's not in my trust, then I hereby want it transferred into my trust. The downside to that is that you will be going through probate to process the will. So it's important, if we're using this type of plan, to make sure that it is fully funded. And then you will also be using, as a single individual with a trust and the pour-over will, you'll have powers of attorney for healthcare and finances. And they really won't be any different than the type that you would use with a will-centered plan. And finally, how about a married couple? So a married couple can have a joint revocable trust, and then each of the married couple will have a pour-over will. And then one extra document will be used when we have a revocable trust as the center of a plan for a married couple, and that is a marital property agreement. It is a standard document to do in our state. Wisconsin is a community property state, and it allows us to have a married couple reach an agreement on how they would like to classify their property, either as individually owned or as owned together. That's called community property. But the big advantage of having that marital property agreement is the use of a thing called a Washington will. And that can be built inside of the marital property agreement, and it will act as another type of pour-over will. But the big advantage is there's no probate. And then, just like the other plans, we need separate healthcare powers of attorney and financial powers of attorney. So those are the documents, the most common documents that you might use to set up your estate plan. So for more information, you'll be given a way to reach out to us either by telephone or on the web to get further information or to set up an estate planning appointment. Thank you.